Good afternoon, everyone. We are starting with our today's session. I'm very pleased that this is happening. The number of participants is currently still growing, so we are starting slowly. I welcome you to our Hogan Lovells TechReg Talks session. It's the second in our webinar series on fast evolving regulatory landscape around emerging technologies and on AI litigation issues in general. So very, very pleased to have you all here, and thank you for joining and to discuss the recent developments in AI and copyright in the US and Europe. My name is Morten Peterson. I'm a partner in our IP practice from Hamburg in Germany. If you can move the slide, please. Here you can see our fantastic team. It's really a group of friends with whom I discuss developments in the AI litigation field quite regularly. It's only a selection. We are a larger group. We have colleagues also in other offices, in other jurisdictions, but this is a selection who you will benefit in our today's session. So let me just introduce our team. We have here from France, Andrea Dufour, who's based in Paris. In Italy, we have Francesco Banterle, who's based in our Milan office. We have in our London office, Alistair Shaw. In the United States, we have Casey McGarrethup from our DC office. And from Germany, I'm joined by my colleague from Hamburg, Victoria Voges. Together, we will walk you through the key legal developments of this year's relating to artificial intelligence and copyright. So please, let's go to the next slide. So as you saw on the invitation, this session focuses on the current landscape of copyright and fair use and how courts and regulators are responding to the rapid integration of AI systems into the digital market. So to open the webinar today, I would like to highlight a few of the central questions that we are seeing and which are many of you probably are also asking yourselves at the moment and which we will be discussing today. So a major topic this year has been the use of copyrighted material in the training of AI models and how such training data should be treated under copyright law. So what is the legal position when protected works are scraped or used to train AI models? And what obligations, if any, fall on developers to clear or license such uses? So in Europe, this leads to the question of whether and how the text and data mining exceptions applies to the development of AI. So what is the current state of the debate among policymakers, courts, right holders, and developers? There's a huge discussion on this. And is the exception functioning as intended in the current landscape? In the US, the discussion revolves around the applicability of the fair use doctrine. Courts there are now considering whether the training of generative models can be seen as transformative. So we will take a look at what direction the decisions are taking, how the different cases are evolving, and what the ongoing settlement negotiations in high-profile cases tell us about possible future developments. So another important topics are the AI models themselves. Can the models infringe copyright by the way they have been developed or by the nature of what they store within them? This year, we have seen notable decisions from Europe on this point, and two just recently from the UK and Germany. And these decisions, we feel, begin to clarify boundaries, but also open new discussions about the nature of AI models and liability aspects. And finally, we come to the output of AI models and the question what the status of the generated output is. So what does it mean under copyright law if a model produces content that reflects or recalls individual works? What is the relevance of memorization or unintended reproduction of training data? The recent and widely discussed court decision in Germany has added new momentum to this debate, and we will take a closer look at that. So this is just a little bit the frame of our session today. And so in the next hour, we will guide you through these developments, compare the trends in the US, the UK, and Europe, and provide practical insight into what they mean for platforms, developers, and right holders. Let's dive right into and start with our first section, namely AI training. Next slide, please. So I'm starting with the US. Casey, can you give us, please, an overview about the latest developments in the in the US around training?
Sure, certainly. The largest developments in this space in the US actually took place over the summer in June of this year, in specifically the United States District Court for the Northern District of California. There, two federal judges in two separate cases concluded that the use of copyrighted works to train AI models, even without explicit authorization to do so, can constitute fair use, at least under certain circumstances. These two decisions that I'll go into more detail about were the first time that a federal court had addressed whether the use of copyrighted materials to train generative AI models could qualify as fair use. So before I get ahead of myself, I should just note a quick reminder of the basics of fair use in the United States. Copyright law in the US looks at four factors in a fair use analysis. First is the purpose and character of the use, often referred to as whether the work is transformative. Second, the nature of the copyrighted work, whether it's more factual or more creative. And third, the amount or substantiality of what is used. And lastly, the effect on the market for the particular work. These four factors judges weigh in their discretion, and no factor alone is often dispositive, but they shape how courts decide what is considered to be fair use. So turning first to Bartz versus Anthropic, the AI firm Anthropic trained its AI model Claude on a mixture of lawfully acquired and pirated books. The authors of these books then sued, centering their allegations of infringement on the use of their copyrighted material to train the AI model. Notably, the plaintiffs did not allege that Claude reproduced any infringing material in their outputs. Judge Alsup out of the Northern District held that training Claude on lawfully acquired books was quintessentially transformative and thus fair use, since the model generated new material without any infringing outputs. His decision, however, was explicit to carve out the pirated works from this determination. So the two main takeaways from this particular case are first, that fair use can apply when training data is accessed lawfully, even if not purchased, which suggests that this might cover lawful web scraping. And second, that fair use applies only if the training does not produce infringing outputs or copies, with the court stressing that otherwise this probably would have been a different case. We can deduce from that mainly this is because the work wouldn't be considered transformative anymore. And then just 2 days later, Kadri versus Meta came down from Judge Vince Chabria, also of the Northern District of California, reaching a similar outcome in a case against Meta. The authors in that case sued Meta for using copyrighted books to train its model Llama, claiming lost licensing opportunities and snippet reproduction. A big piece of Meta's argument was that it had post-trained its model to prevent infringement and that its outputs were transformative rather than substitutes. Unlike the Anthropic court, Judge Chabria centered his decision on the fourth factor of the fair use analysis, market harm. While he agreed that AI training was transformative, he emphasized that the fourth factor, the effect on the market, is the most important, and that had the plaintiffs made an argument that Meta copied their works and created a product to flood the market, then with the market dilution theory in mind, they might have won their case. Ultimately, the court explained that its ruling didn't stand for the proposition that Meta's use of copyrighted material to train its models was lawful. It only stood for the proposition that these plaintiffs made the wrong arguments and bypassed the right one. Of course, though, the ruling didn't necessarily find Meta's conduct unlawful either. So this ruling was not a blanket approval of AI training on copyrighted works. Meta's safeguards undercutted infringement arguments, but Judge Chabria's market harm focus, contrasting Judge Alsup's transformative approach, shows varying judicial approaches to the fair use question. So overall, all things considered in the current landscape of the US, outcomes remain highly fact-specific, and we don't have a clear rule just yet.
Thanks, Casey. Very interesting cases. Elle, I think in the UK you had a recent case as well, right? So can you tell us something about that?
Sure, Mon. Yeah. Hi, everybody. Yeah, you're absolutely right. Just last November, very recently, there's been a ruling on a much anticipated judgment, in this case, Getty Image and Stability AI. And we'll talk about bits of this as we go through the presentation. Just a bit of very brief background right now. Unlike the models that Casey was just talking about, this was a diffusion model. It's an image generator, but essentially the same issues are going to arise. And it was trained on a series of about 3 billion image text pairs, which have been scraped and put together into a package in a Leon 5 data subset. And I know we're going to be talking about the Leon data sets a bit later, so I won't go into that in any more detail. There were 3 products that the defendant Stability AI produced. That was Stable Diffusion, which was the downloadable copy of the model itself, and then one online tool called Dream Studio, and that was hosted outside the UK, and we'll see the significance of that shortly, as well as a developer API platform which developers could use to plug their developments into. And again, that was sitting outside of the UK on web servers, principally in the US. The case which started a couple of years ago was complex. By the time we got to trial, it wasn't quite as complex. It started off with a primary and a secondary copyright infringement case, which was, primary copying is reproduction, communication to the public, and so on. And then secondary copyright, which is essentially dealings in copyright works or infringing copies. There was a database right infringement claim in there, which we'll see was dropped, as well as a case on trademark infringement around the use of Getty's watermarks in the images from its database of images. So, as I mentioned, the case was reduced to secondary infringement on in relation to copyright, and that's because, and we should bear in mind, that copyrights are territorial, and so in the training phase, which is what we're focusing on right now, there had been no training that had been shown to have been done in the UK. And so there are no UK copyrights involved at all in the training process. Okay. So in terms of it not really dealing with too many issues, as a result of there being no evidence of training in the UK, there was no question of any exceptions coming into play. And in fact, if there had been any training in the UK, there would have been no exceptions that would have been relevant, because the UK does not have a text and data mining or a fair dealing or fair use type exception like the EU has, which we'll talk about a little bit more a little later on. So the main takeaway from this case, in terms of practical implications, is that it's still risky to train in the UK because there are no exceptions apply. But that said, as we'll see later, if you train outside the UK, things are a bit different.
With this in mind, I think then in the end, Getty resolved relatively little, right? Do you see any of the legal uncertainties being resolved in the next year?
Well, possibly. I mean, it was a very interesting judgment, very long, very well-reasoned judgment, but the main takeaways are limited. In terms of developments in the year ahead, there aren't, as far as I'm aware, any major cases in the pipeline of that nature. We've certainly got plenty to chew on as a result of Getty, but I think we'll be looking further afield to some of the cases in the EU. And of course, everybody should bear in mind that the jurisprudence and the law of copyright in the UK is very closely aligned with the EU, since we only Brexited very recently. I suppose something that will come up in the next year is the results of a very extensive survey and responses to a government consultation which started at the beginning of this year. We're expecting a government full response in around March, and possibly an update sooner than that. There was a huge number of submissions, as the slide shows. And in terms of the areas we're covering today, aspects that the government are consulting on is whether the UK should introduce a TDM exception, text and data mining exception, perhaps like the EU, aligned with the EU. In questions around the transparency, should developers have to disclose what their models have been trained on, and potential EU AI Act equivalency. And by that I mean, should we be introducing provisions which govern the position of models trained outside the UK when they're deployed in the UK, a bit like the EU AI Act, which my colleagues will deal with later. The effect of these cases and the EU cases we're going to talk about There's going to be furious further lobbying, I'm sure, to the government before that consultation is completely at an end. And I think there'll be a lot of attention paid to where the case law develops in the EU around the TDM exception and the scope of that, which may shape the debate in the UK.
Thank you, El. Yeah, this is hugely interesting. We actually, as you just mentioned, the EU, we are now looking at the frame and the situation in the EU. And now this is for you, Francesco. Can you please tell us a little bit about the European, or I should say, the EU legal framework around AI training?
Sure, Martin. So before walking through the cases in the EU, let's just quickly refresh the current legal framework in the EU, especially since, unlike in the US, there's no broad fair use concept here. So while in 2019, the European Copyright Directive introduced a special statutory exception for text and data mining, the so-called TDM, allowing reproduction and extraction of works from databases for TDM purposes. The TDM exception, particularly for commercial purpose, is subject to two conditions. The first one being access should be legitimate, and secondly, right holders can opt out and reserve their rights, thus limiting these exceptions. And of course, as an exception, TDM is subject also to the three-step test under the Berne Convention, which is a triple test to assess specificity and the prejudice caused by the use. But what exactly TDM is? TDM is defined by the Copyright Directive as any automated analytical technique aimed at analyzing digital text and data to generate new information, such as pattern, trends, and correlations. So while this provision was not specifically designed for AI or with AI in mind, the definition is particularly broad, as you can see, and in particular, the concept of extracting information is basically wide. So it may cover AI training. Then in 2024, the AI Act referred to TDM and the opt-out mechanism as the key EU copyright provision to ensure adequate level of protection against uses of works for AI training. The AI Act added obligations basically to reinforce the opt-out mechanism by setting out transparency reporting obligations and by setting out the need of adopting policies to respect EU copyright and the reservation of rights. And then we have a couple of general principles which are set out in the recitals of the AI Act. Recital 105 expands the scope of TDM rights by saying that in the context of training, any use of copyrighted materials requires an authorization. So basically, the AI Act has broadened the scope of application of the TDM exception, saying that any form of TDM apparently falls within the right of reproduction. And then Recital 106 further expanded this protection, attempting to provide an extraterritorial scope, because it says that developers shall comply with copyright obligations regardless of the jurisdiction in which the copyright relevant acts for training take place. This general principle opens a big point in relation to territoriality of copyright, and as Al just mentioned, and is an open clause that will be controversial. And in general, against this background, we will see that the exact scope of TDM is particularly debated.
Thank you, Francesco. This is a great overview about the TDM exception in the EU. Now, are there already cases where this is really relevant?
Yes, so basically this intricate legal landscape has now led to the first case being referred to the Court of Justice of the European Union. Indeed, in April 25 this year, a Hungarian court asked the Court of Justice to clarify whether training a large language model, specifically which observes and matches linguistic patterns, because the question in this case is linked to the creation of patterns, constitute an act of reproduction under EU copyright law, and in that case, if this falls under the TDM provisions. The referral includes a number of questions, but those two are particularly interesting for our debate today. So the first one is whether the AI training amount to making a copy of the protected work, so in terms of an act of reproduction. Second, in that case, if the TDM provision, the TDM exception can justify those reproductions. So if the TDM exception can apply to LLM training. So in terms of timeline, we are at the beginning of that process. So we can expect that the Advocate General will issue his opinion next year, likely. And we can expect a final ruling in 2027. The outcome of this case will, of course, be crucial because it will be the court will provide guidance on the TDM exception, and we clarify the scope of that exception and if it can apply to AI training under EU law in general.
Thank you, Francesco. So this has been a very nice overview about the jurisprudence of the European Court. And so we now would like to take a look at the EU member states. We start with Germany, where we see quite some litigation going around in AI. First of all, how is it that German courts are deciding cases against non-German or non-EU developers? Does German or EU law even apply here, Victoria?
That's a very good question, Martin. Indeed, German courts are applying European and German copyright law in these AI cases. While that may seem surprising at first, the applicability of German or EU law depends on several connecting factors that are recognized under European and German law. First, under the European Brussels 1A regulation, German courts can assume jurisdiction if the alleged infringement has an effect in Germany. Therefore, the courts can hear the case even if the developer is based in a different EU states. And even further, the German Code of Civil Procedure allows a claim to be filed at the place where the harmful event occurred, even against abroad parties. That means if the infringement caused damages in Germany, the claimant could bring the case before a German court. Once jurisdiction is established, the European Rome II regulation determines the applicable law. And according to Article 8 of that regulation, infringements of intellectual property rights are to be dealt with the law of the country for which protection is sought. This is often called the territoriality principle. So if a party claims infringement of German copyrights, German law applies. Depending on the claim, for example, such involving personality rights rather than copyright, claimants can also rely on German rules of international jurisdiction, which allow them to choose the law of the country where the damage occurred, again pointing to German law. And finally, in several of the recent AI decisions from Germany that we will discuss today, the defendants were not purely foreign entities. Many of them are European subsidiaries of US companies, or they offer their platforms and services directly in Germany and across Europe, sometimes even operating servers or data centers here. So even though the AI training itself often takes place abroad, there are usually multiple jurisdictional links that enable rights holders to bring their claims before German courts.
Yeah, wonderful, Victoria. Thank you. Can you please then give us an overview about those recent decisions?
Of course. As you're already seeing, there are 3 main cases in Germany at the moment regarding AI training and copyright law. And the first one comes from the regional court in Hamburg and deals with a topic that sits right at the intersection of copyright, data mining, and AI training. The case concerns the German nonprofit organization Lion that has built a massive data set of image text pairs that can be used to train AI models. Among these images was one taken by a professional photographer who sued Lion, claiming that the download of one of his photos from a stock photo website in order to include it in the dataset infringed his copyright. In its decision from last year, the court acknowledged that copying the photo could technically be an infringement, but dismissed the claim because the use was covered by the text and data mining exception for scientific purposes. The court applied this exception of copyright law because the defendant's intention, Lion's intention, was scientific research on AI training data, and Lion acted in a non-commercial way, making the results in form of the dataset freely available to the public. Although not decisive for the outcome, the court also addressed the broader general text and data mining exception that also covers commercial use and expressed the controversial opinion that an opt-out against text and data mining by a rights holder might even be valid if formulated in natural language, rather than requiring a technical solution such as a robots.txt file. The decision has been appealed and is pending at the higher regional court now. And in the oral hearing on the appeal, the court extensively discussed the general text and data mining exception and its requirements, in particular regarding the opt-out mechanism. In the oral hearing, the court slightly leaned towards stricter standards on this, suggesting that an opt-out might require more than mere wording in natural language on a website to fulfill the machine-readable requirement. However, it appears likely that the appeal will again be decided on the basis of the scientific research exception, though the court may also take the opportunity to address text and data mining more broadly. So this case is definitely one to watch, as it will likely shape the future understanding of how the text and data mining exceptions apply to large-scale AI datasets in Germany and Europe. The second case, in which we just recently got a decision from Munich, is the lawsuit of the German collecting society GEMA against the ChatGPT developer OpenAI. GEMA claimed that OpenAI's large language models, specifically ChatGPT 4 and 4.0, had memorized and reproduced protected song lyrics, including well-known songs by German artists. The Munich Regional Court agreed and found that the models contained the lyrics in a reproducible way, meaning that they could be reproduced in the output through very simple prompts. The court held that this so-called memorization constitutes a reproduction under copyright law, which infringed the artist's copyrights. It also rejected the applicability of the text and data mining exceptions, reasoning that these rules can only apply to analytical use, not to permanent reproduction stored inside AI models. As an appeal is very likely in this case, nothing is final yet. However, this is a landmark decision, and the case will play an important role in shaping how courts across Europe assess AI training and liability for output. The third important case is also pending at the regional court in Munich and concerns a lawsuit of GEMA as well, directed against the developer of Zuno, an AI music tool. Here, GEMA claims that Zuno has processed protected recordings of world-famous songs from the GEMA repertoire in its tool without paying for their use and therefore infringing copyright. After the last decision from Munich, it seems likely that the court will decide in a similar way in this case. However, these proceedings are less advanced and there hasn't even been an oral hearing yet. So the case will be another one to watch for next year.
Yeah, thank you very much, Victoria. Let's take a look at the situation in other EU member states. Andrea, do you have any pending AI cases in France at the moment?
Thank you, Morten. Yes, there is one case pending in France. So it is an action initiated by 3 French authors and publishers associations, mostly from the books industry. So they issued a statement in March of this year announcing that they have sued Meta in France for the alleged use of protected books and the training of their AI tool, Llama. So the action is pending before the 3rd chamber of the Paris Judiciary Court, which is composed of judges specialized in IP matters. And the claimants invoke 2 different grounds. First, copyright infringement, and 2, free riding, which derives from the general tort provision and prevents a party from unduly benefiting from another's investments. It's often raised as a broader fallback argument to infringement in case the first claim fails. And from the information available online, the claimants argue that Meta is creating books in a new market which directly competes with theirs. And this argument may have been inspired by the US decision presented earlier by my colleague. So what to expect? This would be the first decision in France on AI training, expected, I would say, late 2026. Although given the stakes here, there will probably be an appeal, and we might be looking at a few years before there is a final decision in France. And in any event, France is not a common law jurisdiction, so whatever the outcome, another court would not necessarily be bound by this decision. What we are also expecting is more clarity as to the TDM exception. In France, we do not have a broad fair use theory. Rather, we have a limited list of exceptions to copyright, including the TDM exception, which should apply to AI training. And copyright holders in France recently have been lobbying for a different approach based on the so-called three-step test, which sounds more like a US fair use approach than a French one, but to be continued.
Thank you, Andrea. Francesco, how's the situation in Italy? If we move to the next slide, please.
Sure. Well, Martin, litigation over AI training in Italy is threatened by some rate holders at the moment, but remains at an early stage. No major court decision yet or public pending cases. But we have actually a recent legislative update for Italy because in September, Italy has enacted a new AI law with specific copyright provisions. And in particular, the law introduces a dedicated copyright provision that expressly extends the TDM exceptions to operations carried out through AI models and systems, including generative AI. This means that basically the TDM exception now should cover in Italy also AI-driven users. And the law has also introduced criminal provisions for the violation of TDM exceptions with very small fines, but as a general broadening of the protection. And in general, the intention of this new provision apparently is to clarify that AI users fall within the TDM regime and the reservation of rights. And this is in line with the approach of the AI Act that we mentioned before. However, there are also some unresolved issues, especially in relation to the boundary between the TDM and the full-scale model training. And a key open point remains, so whether TDM exceptions truly cover and apply to model training. So this legislative novel approach confirms the difficulties in scoping exactly the TDM provisions. And there may be also an harmonization issue. So in this regard, further guidance and possibly litigation are expected.
Thank you, Francesco. So this has been the first part. With that, we would like to look at our next topic for today, which is the perspective of AI models themselves under copyright law. Victoria, can I ask you to start with this? The recent decision from Munich was seen as groundbreaking in its view on AI models itself. So what do you think, and what can you tell us more about that and what it means for AI developers?
Yes, this ruling from Munich is indeed groundbreaking in this regard because for the first time, a court dealt with what happens inside an AI model and how that's relevant under copyright law. The court dealt extensively with the concept of memorization, meaning that during training, the model effectively stores parts of its training data in a reproducible way within its parameters. According to the court, this fixation is sufficient to qualify as a reproduction under European copyright law. And it didn't matter that the model represented content as probability values or that no real copy of the song text was stored. What counted was that the model was capable of generating the lyrics through simple prompts, which in the court's view proved that the works were embodied inside the model. It found that coincidence could be ruled out because of the length and complexity of the reproduced lyrics. And that finding that memorization itself equals reproduction is what makes this case so significant. For AI developers, this has the potential for major implications. If other courts follow this reasoning, any model that memorizes protected works without a license could be considered infringing, even if the works are never intentionally reproduced. And it also means that the text and data mining exceptions may not shield developers if memorization cannot be technically prevented.
Thank you. It's super interesting. Just to remind us that this is, of course, a decision which is not yet final. So the appeal on this case will definitely be something to be watched next year. I think it will be probably end of next year or beginning of 27. Now, let's come to the UK, Elle, I think the model itself was the topic also in the Getty case, right?
Yeah, that's absolutely right, Morten. Just a brief explanation of why. It wasn't so much that the court dug into the model as an infringement per se, but it was because of this rather unique, I think, if you like, deeming provision we have in the English UK Copyright Act. So that's section 27.3, a copy of which is on the screen there. And what Getty argued was that even though there was they dropped their output claims in relation to infringing output, and there was no training in the UK. But the assumption was the training, and it was agreed that training was going on in the US. And under our law, if a copyright work had it been made outside the UK, would have constituted an infringement had it been made in the UK. The importation or other dealings with that work is dealing in a deemed infringing copy. So, as I said, the language is set out in full there, and that was a summary of it. So, what Getty were arguing was that by downloading or facilitating the download of the stable diffusion model, that was an importation of an infringing copy. Okay, so the court had to decide, firstly, as a preliminary point, whether a software, in the terms of a download, an intangible, could be an article that could be imported, and the judge said yes. She was fine with that. But she also held that it was not an infringing copy because the model had never consisted of, stored, or contained any copy. Now, this is in contradiction, if you like, to the position that the Munich courts have taken just shortly afterwards. And you may find that surprising, but partly it was based on the evidence, the expert evidence in the English court. The two experts, very, very prominent experts in the machine learning field, agreed that there were no copies stored in the model. And indeed, Getty didn't even allege that. But what they were saying was that by having been trained outside the UK and the exposure of the model to the copies over and over again in the training process resulted in the model itself being an infringing copy. The judge didn't like that. And she reasoned as follows. I'll give you a little bit more detail. She said it wasn't enough that at the time of the making of the copies of those particular works during training, there was a code that coincides with the making of the model. She said that the model weights were altered during the training by exposure to the copyright works, but by the end of that process, the model itself didn't store any copies of the works. She held that the model weights, i.e. the parameters in the model, were not themselves an infringing copy, and they're just purely a product of the patterns and features which the parameters / model weights have learned over time. So it's really of no relevance that the production of stable diffusion involved copyright copying, which had it been done in the UK would have been an infringement, given that the model itself never stored copies. So the takeaway from this case at the moment, pending other cases coming in the pipeline in the future, is that basically training models that are developed in much the same or at least the same way as a stable diffusion, i.e. a deep learning diffusion model, can be commercialized in the UK if they're trained outside. But, that case that Victoria was just talking about, and we'll talk about again, may have some impact on the way that parties argue future cases. If people start to look more deeply at the machine learning literature about memorization and regurgitation. So that's definitely one for watch for the future in the UK.
Very interesting. Thank you very much, Elle. Casey, is this a topic in the US as well?
It is, just in a different way than in some of the other jurisdictions we're discussing today. In the United States, AI models, at least as the current landscape stands, aren't considered infringing works themselves. Courts in the US have generally said that just because an AI system was trained using copyrighted material, the model itself is not a derivative work that infringes copyright. In other words, the trained model isn't treated as a copy or an adaptation just because of the works it has learned from. And we've seen several cases where claims are made along these lines, but the courts have been dismissing them at early stages, probably due in part to the fact that most of the focus at this point is trying to navigate the contours of the fair use assessment in the United States. most of the cases we're seeing, and there are dozens and dozens of them in the US, are focusing on the fair use training question. So I think that will inform the scope of, how AI models are viewed in this context moving forward. But put simply, the status as of now is that US courts aren't buying the argument that the model itself is a copy. They're more interested in whether the training process using copyrighted works as an input can be justified as fair use.
Excellent. Thank you very much. So we are coming to our third topic of today, namely the output of AI models. We saw recently that it can be an issue under copyright law if an AI model memorizes training data and can reproduce it in the output. Elle, I move to you. Can you tell us a bit more about how the output was relevant in the Getty case and what questions remain after that decision?
Yeah, that's a very good question. I managed the answer is questions do remain. The output was of very little importance in the copyright sense because, as I mentioned earlier, the case and the vast majority of a 200-page judgment was focused on the trademark infringement aspects, which did relate to output, but not in a copyright sense. And for those of you who are eagle-eyed and follow these things closely, I'll have to put my hand up to a bit of cheating here on the slide because those images on the slide didn't feature at all in the UK case. We thought they might. They're actually taken from pleadings in the US parallel case, but that would have been the sort of comparison you might have expected if we were talking about did the outputs infringe? Was the lower image, which was output from Stable Diffusion, an infringement of the upper image there, the Getty image picture of a Tottenham Hotspur football player? And the reason it wasn't an issue, and I won't spend too long explaining why it wasn't an issue, was that because by the time we reached trial after 2 years of the proceedings, Stability, the models had moved on and they blocked from using the prompts that would produce the infringing outputs that were alleged based on the copyright works that Getty relied upon. And so there were no outputs to match with any inputs, if you like. Interestingly, and then therefore there was going to be no relief that that Getty could obtain. There was no point running the case through, and they dropped the case during trial on output infringement. There was some interesting comments made by the judge around the responsibility of Stability for the output of the watermarks in a trademark sense. So we can't take too much from that, but she did say that it was not wholly the responsibility of the prompter, the person using the model, the consumer in this, or potentially. She was saying it's a bit more nuanced than that because obviously there's quite a lot of control that the model developer has over it. But that's as I said, that's in the context of an output of a specific set of words rather than an overall image. So we can't read too much into it. If we do have another case where output is an issue, we would fall back on the conventional analysis where you say, well, is the output substantially similar to the work alleged to be infringed? Has the alleged infringer had access to the work? And if they do, then there's a rebuttable presumption that there's been copying. And the argument here would be that, the model has output the work. They've either used it through transparency requirements, perhaps in the future, or disclosure, there's evidence that the model was trained on it, or that the copyright work was so well known and so widely available that the inference would be that it had to have been copied. And therefore, if you like, the transition through the model would result in an indirect copy of the original work. But that would be the traditional analysis. But here, we've heard from the judge and the experts in the Getty case that the model doesn't contain any copies. So how can there be indirect copying? And that's going to be an issue for another day. And as I said just a moment ago, there may be some inspiration English lawyers, UK lawyers can gain from the decisions that are going on in Europe, like Victoria was just talking about around this memorization and storage issue. And we'll, again, have to watch that space and see how the cases develop here if they're if there are new cases brought in the UK. But I think we'll be looking across the English Channel to see what's going on your side of that.
Fantastic. Thank you, Elle. Let's move to the next slide. And Casey, how's the US perspective on that?
Sure. With respect to the AI outputs in the US, whether the output itself constitutes trademark infringement is largely a substantial similarity analysis, which I know we see a lot of parallels in other jurisdictions as well. There, at this point, is no specific AI related considerations in assessing whether one work is substantially similar to another. It's just the classic test of copyright infringement. Phrased another way, at least at this point, the use of AI isn't putting a finger on the scale one way or another if something is substantially similar. And in the US, perhaps one of the most talked about cases is New York Times versus OpenAI. There's also the Getty case that Al mentioned. Like I said, lots of cases happening in the US. But the difficulty with these cases and trying to formulate an expectation for the future or a bright line rule of how to proceed is that it's difficult to do so given how fact intensive these cases are. In the OpenAI case, for example, the result is highly factual and will inform other cases with similar facts, but won't help us fashion a bright line rule when one comes around. Similar to the two cases I already talked about, we're going to have to look at all of these outputs on a work by work, output by output basis. So like I said, might inform cases with similar facts, but in the US just yet, we don't have a clear rule.
So let's come back to the EU. Apart from possible infringements, the protectability of AI output under copyright law is still being very much discussed in the EU. If we move to the next slide, please. Andrea, how's the situation with AI output in France?
Thanks, Morten. So as to protectability of the output, we do not expect actually copyright law to change. The criteria of originality is expected to remain the same, so that of the mark of the author's personality. This has been the case for 2 centuries, and it is sufficiently broad to cover any type of work or tool used. It's the criterion that was applied when digital cameras were created, for instance, and courts had to assess whether a photographer could benefit from copyright protection if they used a camera. The typical question is the camera creating the work or is the photographer? Similar question that we would have now. Courts had to assess also when an author was using software to compose music, whether he had copyright or not. So this criteria survived other technological changes and should be applied the same. Of note, there is no copyright office in France, and declaratory judicial actions are rare, meaning you cannot just seize a court to get an opinion on whether your work is original or not. The court has to solve an actual dispute. So we should see the first guidance from courts on this question within a counterclaim for lack of originality within a broader copyright infringement action. And regarding infringement in the output, here as well, we do not expect any changes to copyright law, but rather a new interpretation by French courts.
Merci. Right. So to close today's session, let's come back to Germany and to the next slide. Yes, to this slide. Thank you. Victoria, can you tell us a bit more about the module output was relevant in this recent decision from Munich?
Yes, the output of the model was a key element in the Munich decision as well. The court held that when the model reproduces copyrighted material in its responses, in this case, the full song lyrics, this also constitutes an infringement of both the reproduction right and the right of making works publicly available. What is particularly important is how the court connected the output to what happens inside the model. In its view, the ability of the model to generate the lyrics in the output was seen as proof that the works were memorized within the models, and the judges therefore considered the output as the visible consequence of the underlying reproduction. From a practical perspective, this reasoning leaves developers with 2 possible routes. Either ensure that models do not memorize copyrighted content, or obtain licenses for the data used in the training. At the same time, the court's reasoning raises practical questions for implementation. If no reproduction gets displayed in the output, it becomes very difficult in practice to determine whether memorization has actually occurred. And this shows that there's still some uncertainty about how these cases will be handled in the future. And it's also important to note that the Munich decision is, as was already said, very likely to be appealed as well. So this is probably not the final decision on this matter.
Right. So we move to the next slide. Apart from copyright law, there have been some other recent decisions regarding liability around AI from Germany. So can you briefly share your insights on that, please?
Yes, there have indeed been two other interesting decisions from Germany that go beyond copyright and address different aspects of liability around AI. The first case comes from the regional court in Berlin and concerns a well-known German voice actor who sued a YouTube creator. The creator had used an AI tool to generate a synthetic voice for two of his videos that sounded almost identical to the actor's distinctive voice. The court decided in favor of the actor, confirming that the person's voice is protected under the right of personality in Germany, and using a voice that is recognizably similar without consent constitutes an infringement, even if this voice is AI generated. The court rejected the defenses based on artistic freedom, satire, or freedom of speech, emphasizing that the defendant's aim was mainly commercial and that the video's political content could damage the actor's reputation by creating the false impression that he supported those views. Interestingly, the claim was directed against the video creator only, not the developer of the AI tool he used. And it remains to be seen whether such lawsuits will also be directed against the providers of AI tools in the future. And the second case concerns a preliminary injunction issued by the Hamburg Regional Court regarding a statement of XAI's chatbot Grok on the social media platform X. The bot had published a false factual statement. Sorry, next slide. False factual statement about a German NGO claiming it received federal funding. As the statement was untrue, the court held that traditional German media and defamation law applied. It found that XAI, as the operator, was liable for the AI-generated statement since it had been published under its control, and the fact that the statement came from an AI made no difference. Users would still perceive it as a factual claim, possibly even one with added credibility, because the chatbot claimed its statement was based on facts. Just as a final remark, together these cases illustrate three important points. First, AI-generated content can trigger traditional personality and defamation liabilities. Second, claims can be directed against the operators of AI tools as well as users that spread AI content for their own purposes. And third, German courts are not hesitating to apply existing legal principles to AI output. They are treating AI as a new context, not as an unregulated space.
Yeah, thank you very much, Victoria. And with that, we are at the end of our today's session. I hope it has been useful for you and you have liked our content. You have here our contact details. We don't have time now to answer questions, but we would be very happy if you reached out to us and could stay in touch on any queries that you may have. Thank you very much for joining us and wishing you a great day. Bye-bye.